I spent 11 years as a corporate litigator before I ever had to fight for myself. 11 years watching other people's families tear each other apart over money, over property, over things their dead relatives never imagined would become weapons. I thought I was immune to it. I thought knowing the law meant knowing how to protect yourself. I was wrong. And my uncle made sure I learned that the hard way. My mother died on a Tuesday in October. Pancreatic cancer. She had been sick for 8 months, and even knowing it was coming didn't make the morning of her death feel like anything other than the floor dropping out from under the world. I was 31. She was 59. And the last thing she told me, in the hospital room that smelled of antiseptic and old flowers, was that everything she had built was mine. That she had made sure of it. Her name was Beverly Crane. She went by Bev to everyone who loved her. She had started her interior design firm out of a spare bedroom when I was 4 years old, built it into something real over 30 years, and sold a controlling stake to a larger firm in Phoenix when her diagnosis came through. Because she was nothing if not practical, that sale left her with a settlement account, a consulting retainer, and a trust document she had revised 3 times in the last year of her life. My name was in that trust. My name only. My uncle showed up at her funeral in a suit I had never seen him wear before. He hugged me at the gravesite and said, "Your mother would want us to look after each other." I remember thinking that was an odd thing to say. My mother had never asked him to look after anything in her life. His name is Douglas Crane. He is my mother's younger brother by 6 years, and he lives in Scottsdale in a house that has been refinanced 4 times. I know that because I looked it up later. At the time, I only knew him as the uncle who showed up at Christmas with a bottle of wine he hadn't paid for and stories about deals that never quite closed. My mother had loved him the way you love someone you've given up trying to change. Patiently. From a distance. 3 weeks after the funeral, I received a letter from an attorney I had never heard of. The letterhead said Prescott and Lowe, with an address in Tempe. The letter informed me that Douglas Crane was disputing the validity of my mother's trust on the grounds of undue influence and diminished capacity, and that he intended to seek an equal distribution of her estate under Arizona intestate principles, should the trust be invalidated. I read it twice. Then I put it face down on my kitchen counter and didn't touch it for 2 days. I want to be honest about those 2 days. I am a litigator. I have handled estate disputes from the other side of the table. I know exactly how these cases work, what the arguments are, what the discovery looks like, what it costs to fight, and what it costs to fold. And I still sat in my apartment for 48 hours feeling like a person who had never been inside a courtroom in her life. Grief makes you stupid in ways that competence cannot fix. I cried in my car, I ate cereal for dinner. I called my best friend Tamsin at 11 at night and couldn't explain why I was crying. Only that my mother had been dead for 3 weeks and her brother was already trying to take what she had left me. Tamsin said, "So you're going to destroy him, right?" I said, "I'm going to try. My name is Alana Crane. I am a litigator at a firm in Denver. I am 32 years old. I drive a used Subaru, and I have my mother's handwriting on a no-card taped to my monitor that says, 'Do the work first, then rest.' And I am telling you this story because what happened in that hearing room in Maricopa County is something I have never told in full to anyone, not even Tamsin, and I think it is time." Douglas had retained an attorney named Fowler. I had met the type before: expensive haircut, economy of motion, the particular confidence of someone who charges $400 an hour and has learned to make silence feel like a threat. He filed a petition to invalidate the trust on 2 grounds. First, that my mother lacked testamentary capacity during the revisions made in the final 8 months of her illness. Second, that I had exercised undue influence over her during that same period, having moved to Phoenix for 3 months to help with her care. That second argument made me physically nauseous, not because it surprised me, because I knew it would work on a jury. The image of a daughter swooping in during a parent's illness, positioning herself, steering decisions. I had used versions of that argument myself, on behalf of other clients in other cases. I knew how it played. What Fowler did not know, what Douglas almost certainly did not know, because my mother had been careful in ways that her brother never credited, was what was sitting in a safe deposit box at a First National branch on Camelback Road. But I am getting ahead of myself. The first hearing was a status conference. Procedural, nothing dramatic. I had retained outside counsel, a woman named Adira Solis, who I had known since law school and who specialized in trust litigation. I was not going to represent myself. I knew better than that, but I sat at the table with Adira and I watched Douglas across the room and I tried to understand what he thought he was entitled to. He wouldn't look at me. That told me something. Fowler moved quickly. He requested my mother's medical records going back 18 months, her communications with the trust attorney, and my phone records for the period of my stay in Phoenix. That last request was meant to rattle me. It rattled me. I called Adira from the parking garage after the hearing and said, "He's going for the caretaker narrative." She said, "I know. We expected this." I said, "Expecting it doesn't make it less disgusting." She said, "No, it doesn't." The deposition was scheduled for 6 weeks out. In the meantime, I flew back to Denver, went back to work, billed my hours, sat in my own clients' depositions, and spent my evenings going through every document I had from my mother's last year. Every email, every voicemail I had saved, cards she had sent me, cards I had sent her, the notes I had taken when she talked about the trust, about what she wanted, about why she had revised it. What I found, what I already knew was there but had not let myself think about clearly, was a pattern. Douglas had reached out to my mother 4 times in the 8 months of her illness. 4 times after years of sporadic contact. Each time, the conversation had eventually turned to the firm, to the settlement proceeds, to what her plans were. My mother had told me about 2 of those calls while they were happening. She had been tired and sad about them in the way you are sad when someone confirms what you already knew about them. What I did not know, what I discovered in those evenings of document review, was that she had recorded 2 of those calls. My mother had started recording her phone calls after a contractor dispute in 2019. It was legal in Arizona under the one-party consent rule. She had a recording app on her phone that she used occasionally for business conversations, and apparently she had used it on the 2 calls with Douglas that troubled her most. She had never mentioned it to me. I found the files on her old iPhone, which I had in a box with her other things, and I sat on my apartment floor at midnight listening to my dead mother's voice explaining to her brother, patiently and clearly, that she had thought very carefully about her estate planning and that her decisions were her own. In the second recording, Douglas said, "Alana has been in your ear this whole time, Bev." My mother said, "Douglas, I revised this trust twice before Alana came to stay with me. You can look at the dates." There was a pause. Then he said, "I just think it's not fair. I'm family too." She said, "I know you do." She did not say he was right. I listened to that exchange 6 times. Then I put the phone down and sat very still in my apartment for a long time. Because my mother had known this was coming. She had known her brother would do this, and she had quietly, practically, in the way she did everything, left me what I needed. She had just not told me it was there. Maybe because she hoped I would never need it. Maybe because she did not want to spend her last months explaining to her daughter why her brother could not be trusted. I forwarded the files to Adira at 1 in the morning with a message that said, "She recorded him. Arizona one party. 2 calls. He says on tape it's not fair and she pushes back directly. This is capacity and intent, both." Adira called me at 7 the next morning and said, "Where did you find these?" I said, "Her phone, in a box." There was a pause, and then Adira said, in the particular tone of someone trying not to sound too satisfied, "Okay, we're going to be fine." The hearing was in November. A probate court proceeding in the Maricopa County courthouse, fluorescent lighting, wood paneling that had not been updated since the 90s, the low-grade hum of institutional air conditioning. I had been in hundreds of rooms like it. I sat next to Adira and I kept my hands flat on the table and I breathed. Douglas was across the room with Fowler. He was wearing the same suit as the funeral. He looked older than I remembered from the deposition, or maybe I was just looking at him more carefully. There was something slightly rehearsed about the way he was sitting, a performance of confidence that required visible effort. Fowler opened by framing the case in exactly the terms I had anticipated. a vulnerable woman, late-stage illness, cognitively compromised by pain medication and fear, and a daughter who had inserted herself into a caregiving role that gave her unique access and influence. He was good. I will give him that. He used the word isolation 3 times in his opening. He made it sound as though I had drawn a curtain around my mother and let no one else in. What he did not know was what Adira had filed under seal the week before. He found out when the judge admitted the recordings into evidence. I watched Fowler's face when the judge read the exhibit description. There was a very brief moment, less than a second, where his expression shifted. Not panic. Lawyers don't panic in courtrooms. But a recalculation. A rapid internal reassessment that he smoothed over immediately and professionally, and that I recognized because I have done it myself. Douglas, across the room, leaned toward Fowler and said something in a low voice. Fowler put a hand up slightly, a quieting gesture. The recordings were played in full. My mother's voice in that room was the hardest thing I have ever sat through professionally. I have cross-examined grieving widows. I have watched families say terrible things about each other under oath. I have, as Tamsin would say, seen some things, but hearing my mother's voice in that fluorescent-lit room, calm and precise, telling her brother that her decisions were her own, I had to focus on a fixed point on the wall and breathe very slowly and let it be what it was. When the second recording ended, the room was quiet for a moment. Douglas was looking at the table. Fowler requested a brief recess. The judge granted 10 minutes. I watched Douglas stand up and walk out into the hallway, and I thought about the conversation my mother had described to me in her hospital room about what she wanted me to know. She had said, "I've made sure of it." She had not told me about the recordings, but she had told me that she had made sure. She had. She had made sure in her own way. In the practical, quiet way she did everything, and she had trusted that I would find it. When the hearing resumed, Fowler's entire posture had changed. Not dramatically, subtly. The particular shift of someone who has revised their expectations in real time. Douglas did not take the stand in his own behalf. His attorney called one witness, a physician's assistant from my mother's oncology practice, who testified about the medication regimen during the last 8 months of her life. Under cross-examination by Adira, the witness confirmed that my mother had been lucid, communicative, and engaged with her medical decision-making throughout her treatment, that she had asked detailed questions, that she had been described in clinical notes as cognitively intact at every visit. The capacity argument was dissolving in real time, and Fowler knew it. The undue influence argument required something more from Douglas's side. Some showing that I had been in a position to override my mother's judgment and had actually done so. The recordings made that nearly impossible. There was my mother, on tape, explicitly and voluntarily pushing back against the characterization that I had influenced her. There was the trust attorney's testimony, which Adira had also secured, confirming that my mother had arrived at her appointments alone, asked her own questions, and made her own revisions. By the afternoon session, Fowler was arguing at the margins. The technical language of trust law, the standards of proof, the procedural posture of the case. The substance had already shifted. Then Adira asked Douglas on cross-examination about the calls. He had to admit he'd made them. The recordings established that what he had not expected was the follow-up question. Adira said, "In those calls, did you ever tell your sister that you believed her trust arrangement was unfair to you personally?" He said, "I expressed concerns, yes." She said, "And those calls took place before Alana returned to Phoenix to help with your sister's care, correct? In the early months of her illness?" A pause. "Some of them, yes. So your concerns about the estate predated your niece's involvement. It was not a question." He opened his mouth and closed it. Fowler said, "Objection, argumentative." The judge said, "Overruled. You can answer." Douglas said, "I just wanted what was fair." Adira said, "And what your sister told you on 2 recorded occasions was that she had made her decisions carefully and they were her own." He didn't answer. The judge sustained no objection because Fowler hadn't made one. There was a beat of silence in the room that felt longer than it was. The petition was denied. The judge ruled from the bench at the close of proceedings, which was faster than I had expected and slower than I needed it to be. She found that the petitioner had not met the burden of proof on either capacity or undue influence, that the evidence of record supported the trust's validity, and that the trust would stand as written. My mother's estate passed to me as she had intended. I walked out of that courthouse into the November afternoon in Phoenix and sat on a concrete bench outside the entrance and did not move for about 5 minutes. A man in a blue blazer walked past me talking on his phone. Two paralegals I didn't know shared a cigarette near the parking structure. The sky was that particular sharp blue you get in Arizona in November, no clouds, the kind of sky that looks painted. I called Tamsin. She picked up on the second ring and said, "Well?" I said, "It's done." She was quiet for a second. Then she said, "Bev won." I said, "Yeah, she did." I didn't see Douglas leave the courthouse. I don't know what he said to Fowler in the hallway, or what he went home and told his wife, or what he thought about on the drive back to Scottsdale. I stopped trying to understand what he had been thinking almost as soon as the ruling came through. Understanding it required a kind of generosity I didn't have access to that afternoon. What I did know was this: my mother had built something for 30 years. She had built it alone, and she had protected it carefully. And at the end of her life, she had been practical enough and clear-eyed enough to leave behind exactly what was needed. Not a message, not an explanation, not a dramatic gesture. Just two audio files on a phone in a box, quiet and sufficient and entirely like her. The firm she had spent 30 years building. The trust she revised 3 times. The phone she used to record 2 calls because she was a businesswoman who knew how disputes were settled. There is a note card on my monitor with her handwriting. Do the work first, then rest. She did the work. I just had to find it. 3 months after the ruling, I was back in Denver, back in my office, back in depositions and motions, and the ordinary traffic of other people's emergencies. A new client came in. A woman my mother's age, soft-spoken, recently widowed, with a stepson contesting her husband's trust. She sat across from me and said, "I don't understand how he can do this." My husband was very clear. I said, "Tell me everything. And if there are recordings, emails, anything in your husband's own words, find them. Don't assume you know what you have." She looked at me for a moment. She said, "You sound like you know." I said, "I do. I don't carry the case with me the way I thought I would. What I carry is the image of my mother in that hospital room telling me she had made sure of it. And the sound of her voice on those recordings, patient and steady, and not afraid, talking to a man who thought she was vulnerable and finding out she was not. She was never vulnerable. She was sick, and those are not the same thing. She made sure I knew the difference. I used to think that preparation was the same thing as protection. That if you knew enough, studied enough, worked hard enough at the right things, the worst outcomes would simply not find you. My mother believed something quieter than that. She believed that you do the work that is in front of you, thoroughly and without shortcuts, and that the work itself becomes the protection, not because the universe rewards it, but because careful action leaves a different kind of trail than careless action does. Douglas was careless, not in the way that is immediately obvious. He hired a competent attorney, he filed on time, he presented arguments that were technically coherent, but he was careless in the deeper sense. He assumed my mother had not thought ahead. He assumed that a woman who was sick and tired and spending her last months trying to be present with the people she loved had left gaps he could walk through. He built an entire legal strategy on the premise that she was less prepared than he was. She was more prepared than either of us. What I keep coming back to is the nature of what she left behind. She did not leave a dramatic letter. She did not sit me down and explain what Douglas might do. She recorded 2 phone calls, filed the recordings on her phone, and trusted that if the situation ever required it, I would find them. That is not luck. That is a person who understood cause and effect with clarity, who knew that Douglas's pattern of behavior, the refinanced house, the deals that never closed, the sudden reappearance when there was something to gain, would eventually produce a specific outcome, and who prepared for it quietly and without drama. There is something I want to name about what Douglas did, because I think it matters beyond this particular story. He did not just try to take money, he tried to rewrite what my mother had been. His entire argument rested on the claim that she had been diminished, cognitively, emotionally, in her own judgment, and that her decisions in the last year of her life were not really hers. That is a particular kind of cruelty. It is the attempt to make a person's final choices mean less than their earlier ones, to use their illness as evidence against their own mind. The recordings dismantled that, not because they were dramatic or damning, because they were ordinary. My mother, on those calls, sounded exactly like herself, measured, patient, clear, slightly tired of having to explain herself to someone who should have known better. That ordinariness was the evidence. She was not diminished, she was just sick, and she had known that people would try to confuse those two things. What I learned from watching this unfold is that integrity is not just a moral quality, it is a practical one. The choices my mother made over 30 years, building carefully, documenting thoroughly, thinking clearly about what she wanted and why, those choices produced real-world consequences that her brother's choices could not undo. He had spent years taking shortcuts, and when it mattered, he had nothing solid to stand on. She had spent years doing the work, and when it mattered, the work was still there. I think about that when I sit across from clients who are frightened and exhausted and do not understand why someone they trusted is doing this to them. I tell them what my mother's life showed me, that the people who try to take things they did not earn are almost always relying on the assumption that you were not paying attention. The most powerful thing you can do is prove that you were.